Muted. Thanks, Erwin. Can you see the PowerPoint I got up? Okay,
yes.
Great. So as Jamie said, Jeff Hearn, Director of Litigation here at Legal Services. I've been doing landlord-tenant work for almost 20 years now. And I also teach the Tenants' Rights Clinic at the University of Miami, where students work on landlord-tenant cases. So I want to thank everyone for participating tonight. We're going to try to keep this right at an hour. And we are really looking forward to having you work with us to help with the evictions that we're expecting over the next few months and going forward. So this is a little bit of an adapted training. We recruited pro bono lawyers to do evictions since for many years. And we've adapted it to deal with COVID. So we'll talk a little bit about evictions first and the process, and then we'll talk about all the new changes related to COVID. But I'd like to start out with to have everyone keep in the back of their mind, that we're talking about somebody's home here, right? They may not own the property, but it is the place where they call home. And even though they rent it, it's still a protected property interest. Even the 11th Circuit has said that and said it's one of the most important property interests. So I like to keep that in mind. I think sometimes we sort of think as tenancies as less important or less of a home than where somebody owns the property. But really that's not the case. So why do we do a lot of eviction work? We actually have 8 or 9 lawyers in our office who are dedicated just to representing tenants. One of the reasons, evictions really trap people in poverty and cause poverty. The book Evicted by Matthew Desmond won the Pulitzer Prize a few years ago. If you haven't read it, I really would encourage you to do so. It really said that evictions cause poverty because, moving costs money, having to come up with security deposits, and then taking time off work and losing income, and then children changing schools, and that it's this, the housing instability really keeps people in a position where they can never get ahead. So anything we can do to help sort of interfere and break that down is good for our clients and for the community. And I don't need to tell you all that housing in Miami-Dade County is unaffordable. It really is the area we have the most need, even before the pandemic, of people contacting us. More than half of the clients who reach out to us contact us about a housing issue. And you're going to see that the eviction process itself is not user-friendly, and having an attorney makes a big difference for that client. And what's really important is that the work that you're going to do is going to have a huge impact on that client and on that family's life. So that was all true before the pandemic, and now we are, dealing with the crisis that we have at hand. And you all know that the infections, the hospitalizations, and deaths remain high, especially in Miami-Dade County. In Florida, we've had 3.2 million unemployment assistance claims filed. 3.2 million, that's a lot. And the federal unemployment ended last weekend. So a lot of people who've been able to get by with that $600 extra per week have now lost that. And now if they're still eligible for benefits, they're only going to be getting at the most $275 a week. And that's not going to help people who may have been able to stay current up through August. They may now have financial issues staying current with their rent. So the census does a survey each week, and this is from July 21st, so it's a little bit a week behind. But you'll see that this is the confidence that families have in making the next month's rent. And you'll see that Florida is above the U.S. average, and Miami in particular is far above the national average. So, almost 75% of tenants in Miami have some concern that they may not be able to make next month's rent, which would be August rent. So if you take those numbers, there's a consulting firm that took the numbers from Florida and went out and extrapolated from those, and it's pretty conservative in some of its numbers. If you take that and apply it to the number of renters in Florida, we could have as many as 800,000 evictions filed in the next 4 months in the state, which is a really, really scary number. You know, never seen something like that before. So we are dealing with, well, it's both an economic crisis. People don't have the income to stay current on their housing, but it's also a public health crisis, because if you lose your home and shelter, what are you going to do to protect yourself from the virus? This is a photograph of a woman on Miami Beach who was in the news last September, actually, as Hurricane Dorian was approaching. At that time, we thought it might come to Miami as a very strong hurricane. And as all of us were preparing our homes, hunkering down, the sheriff came and executed on a writ of possession, evicting this elderly woman from her apartment on Miami Beach. And this is exactly sort of the situation that we're trying to avoid, right? We don't want somebody being put out during a state of an emergency. There was some legislation in Tallahassee that didn't advance to try to prevent this, but we do have some policies here locally, which we'll talk about, that help a little bit. So what we're going to do, like I said, we're going to go through the eviction process, walk you through how it happens, how tenants respond to it. Then we'll talk about the law and the protections that are out there, the moratorium, some of the federal laws, and how that sort of interplays with the eviction process. So the applicable law here is Chapter 83, Part 2. It's Florida's Residential Landlord-Tenant Act. And when an eviction is filed, it is filed under summary procedure, which is in Chapter 51. So what that does is it sort of changes some of the timeframes. So the rules of civil procedure are going to apply in evictions, except where summary procedure says otherwise. So we'll talk about some of those deadlines. The idea behind summary procedure is it's supposed to move fast and quick, and so it shortens a lot of time frames, limits some of the procedures that can be done. And then because all of the cases that are filed, evictions that are filed in county court, there's not a lot of case law out there that gets to the District Court of Appeal level. So most of the cases that we look for are going to be either in the county court or at the circuit appellate panel. And we're going to give you an outline when you take a case that has all the defenses, cites to cases you can rely on. And many of those cases are going to be cites to Florida Law Weekly Supplement, which is where those trial court opinions are. And if you need help accessing that or accessing a case that's listed in the outline, we're happy to try to help with that. So what are the different types of evictions? Of course, the most common one is non-payment of rent. That is, and that's what we're sort of expecting to see the most of, in the next few months. The next one are other sort of lease violations. Those are less common, especially in sort of in housing that doesn't have any sort of rental subsidy. But this is when the tenant doesn't comply with some other lease term other than paying rent. Maybe they have a guest that's, somebody living there that's not listed on the lease. Maybe they have a pet when there's a no pet clause, things like that. Then so many of our clients in the low income community, they don't have leases. They just moved in and agreed to pay someone a monthly rent. Those are month-to-month tenancies. We also have people whose lease expired, but they never signed a new lease, so there's no new lease term, but they just keep paying their rent each month. In those cases, the landlord can terminate that tenancy if there's no lease term for no reason. Then you also have some evictions where it's the end of the lease and the landlord then immediately files an eviction, but those are less common. So when we're talking about evictions, we always start with the notice of termination. So before the landlord can file an eviction, the landlord must terminate the tenancy. And they do that by sending a notice to the tenant. And the reason why we focus on the notice is because the notice is a condition precedent to bringing the lawsuit. So if the notice is defective and they don't properly terminate the tenancy, then the tenant has a defense to that eviction. And that's pretty much true for everything. There was a change in 2013, which we'll talk about in a few minutes, for non-payment cases only. But generally, if the notice is bad, then the landlord will not be able to proceed with the eviction because they hadn't complied with the condition preceding. So what does that notice look like? So in the non-payment context, it has to be a 3-day notice to pay or vacate. So it's the landlord telling the tenant, you owe me rent, here's the rent, and pay it within 3 days, or else move out of the property. For the other types of lease violations, the statute requires that the landlord provides 7 days notice. If it's a serious lease violation, either property destruction, maybe some sort of criminal activity, then the landlord can immediately terminate the tenancy and tell the tenant to vacate in 7 days. For other types of lease violations that are less serious, the landlord is required to give a notice to cure, telling the tenant, hey, don't do this again. You've got 7 days to cure it. Let's say you have a pet there and there's a no pet clause. Get rid of the pet within 7 days. And if you do it again within the next 12 months, we can terminate the tenancy and file the eviction. For those month-to-month tenancies, Florida law only requires 15 days notice, which really isn't a lot of time. So, on August 15th, if the landlord says, you know what, I don't want you to be my tenant anymore, I'm terminating your tenancy. It has to end at the end of the month. So on August 31st, your tenancy is terminated, you must move out. Well, anyone moving, even before the pandemic, trying to find housing and move out of a location with only 15 days notice is not a lot of time. So a couple of jurisdictions, Miami Beach and the city of Miami, have extended that notice period for month-to-month tenancies to 30 days. And a lot of landlords don't know about that. So sometimes you'll see landlords who try to use the 15-day notice and they don't do it properly in those cities and jurisdictions. I believe there's the county's housing plan that was just proposed by Miami Homes for All last month includes a proposal to include it countywide to 30 days. Expiration of lease, like I said, doesn't come up very often. There still needs to be a written lease, but always look to the lease to see what it says about terminating at the expiration of the lease term. And then the other thing you always need to look for is, does the lease actually provide more notice? So, for example, we have a lot of landlords who go online, they find a lease, and it says that the landlord must give blank days notice to the tenant before terminating the tenancy. Well, sometimes landlords write in numbers there like 30 days. Well, if they write in 30 days, then the notice needs to be a 30-day notice. So that's something that we sometimes see, is that the landlords don't actually comply with their leases. So the landlord sends the notice telling the person to get out. The tenant still stays there. Then what's the landlord's next step? They can then file the eviction action. So the eviction is a lawsuit where the landlord is asking for possession of the property. So the landlord has to file that in county court. And in Miami, where that's filed, because we have a bunch of branch courts, depends on the zip code of the property. So the zip code will dictate which of these branch courts the case will be filed at. And as you can see, they're all over the county. And those numbers there, that shows up in the case number. So if you're unfamiliar with county court, you'll have your 2020 dash the case number dash CC, meaning county court, and then the next number in that will be the branch court that you're at. And to figure out which judge you have to go look at the judicial section on the docket and then find out which judge that is. So most landlords, well, I wouldn't say most, a lot of landlords just sue for possession, especially for our clients, right? Clients who probably aren't really going to be collectible. And even if they are, it's just not worth the trouble because we're talking about relatively small amounts of money. But if the landlord decides they want to sue for both possession and for breach of contract for the rent, they can include a second count for damages for the breach of contract. But that count is going to proceed under the rules of civil procedure. And they're going to, and they're actually going to have to get service. So for the eviction count, because it's in rem relief, they're just trying to get possession of the property. Of course, they can serve the eviction on the tenant by, with personal service. But if they aren't able to get personal service and they've tried 2 times, then they are allowed to post the summons and complaint on the property door. The clerk also mails a copy to the property. Now, if they're bringing that second count for damages, they have to get personal service. So here's what the summons looks like here in Miami-Dade County. You'll see that there's it's pretty small print. There's a lot of information on here telling the tenant what they need to do. And unfortunately, for a lot of our clients, they don't always see what they're supposed to be, what they need to do. And we'll talk about some of the other steps that they have to do that can sometimes be fatal to their case. So as I said, we're under summary procedure. So this is where the rules sort of change a little bit. The tenant has 5 days to file their response and answer to the eviction lawsuit. And that excludes weekends and holidays. So if it's a regular weekend, it's going to be a week from whenever they get served with the lawsuit. Summary procedure says that all defenses have to be contained in the answer. So what you're going to do with an eviction answer is going to be a little different than what you would normally do. If you have a basis for a motion to dismiss, you're going to file your answer and a motion to dismiss at the same time, because it all has to be brought together. You're not waiving anything by filing both an answer and a motion to dismiss simultaneously. General motion practice is allowed. The Supreme Court said that in the Pro Art Dental case. And counterclaims are allowed under the statute explicitly. The landlord's supposed to respond within 5 days to that counterclaim as well. Jury trials are allowed in summary procedure. So you do need to look to the lease to see if it's been waived, but a tenant can demand a jury trial. Our practice in our office is always to demand a jury trial. If we're representing a tenant, we would much rather go to a jury who's not, maybe more uncomfortable about evicting a tenant than a judge who evicts people on a daily basis. And we're very successful when we have the rare jury trial on evictions. So you would file your answer, you file your motion to dismiss. If there's a counterclaim, bring it, demand your jury trial. Also include your demand for attorney's fees and costs. Because there is a fee shifting provision in Chapter 83, which allows prevailing party to collect their attorney's fees and costs. As a pro bono lawyer, you can collect attorney's fees and costs if you're prevailing party. You just can't charge them, obviously, to the client. And then what else you'll also have to file is a motion to determine rent, if that's appropriate. We'll talk about that in a lot of detail in a few minutes. But before we get there, I do want to talk about some of our common defenses. I'm not going to go into a lot of detail on every potential defense. As I said, we'll give you an outline of, I think it's 30 pages of potential defenses that you could raise. But I want to highlight some of the most common ones. As I mentioned before, we always look for the notice to see if the notice is defective in any way. So, we count the days. Sometimes even attorneys can't count days right, so you get notices of wrong days. If the landlord mails the notice, in a 3-day notice, if they mail it to the tenant, they're going to have to add mail time on the time for the notice. The law says that the landlord can only ask for the precise amount of rent. So sometimes you'll see see landlords who start tacking on extra charges into the 3-day notice, and that's not allowed. There is an exception though. If the lease defines these extra charges as rent, then it can be included in the 3-day notice. For other types of notices, some of the more common ones, if it's something that the tenant should have been given an opportunity to cure, then maybe the landlord didn't do that. So that's another reason why notices are sometimes defective. But for most of the notices, there is language in the Act which says that any notice has to be in substantial compliance with the statutory language. So if there's any variation at all, that may give you a basis to say the notice is defective. As long as it's a substantial, something significant, you can justify why it's defective. So up until 2013, if that notice was bad, you could get the case dismissed. But in 2013, the legislature changed the statute and says that for non-payment cases, the landlord has to be given an opportunity to fix it before the case is dismissed. There's some judges who think that applies to any eviction because actually the judicial training materials tell the judges that it applies to all types of notices. But if you read the statute, and there's some cases directly on point on this, it only applies in non-payment cases. But it's a little strange because you're amending something that's a condition preceding, so it leads to some strange situations. But just be aware of that if you're handling a defective notice case. So here's an example of what the 3-day notice looks like. This one is one that a landlord sent in May, but it actually has a defect in it. I don't know if you can notice yet. I'm not going to give you a lot of time to scrutinize it, but if you look at the date of the notice, it was sent on May 15th, and it tells the tenant that they have to pay the rent by May 15th. So that's not 3 days. So this landlord didn't properly terminate the tenancy, and this tenant's going to have a defense to the eviction. Other defenses, waiver. Sometimes landlords continue to accept rent from tenants. They may say, I'm evicting you because you had a loud party at the property. Well, if they accept rent after that non-compliance, then they waive their right to evict. And in the non-payment context, where you see that oftentimes are these sort of partial payments, where a landlord may send a 3-day notice and the tenant offers up $500 and the landlord takes it. That really is waiver. In 2013, which was a year where there were a lot of changes to the law, the legislature said the landlord can actually do that. They can take a partial payment, but they have to comply. They have to give a receipt, serve a new 3-day notice, and deposit the rent with the court. And very few landlords actually comply with that requirement. So if you have a tenant, or if you have a landlord who's accepted partial payments, they probably didn't comply with the law, and they probably waived the right to evict. Failure to maintain premises. So this is a defense that can often be raised as a defense to non-payment, where it's clearly an absolute defense to an eviction for non-payment of rent is if the tenant first sent a notice to the landlord, giving the landlord 7 days notice that if you don't fix these issues in my unit, I'm going to withhold my rent. If the tenant does that, they've got the law says it's an absolute defense to an eviction. Unfortunately, there's a lot of tenants who don't know about that, so they don't go through the proper steps to do that. So, I always, if I'm representing a tenant where there's conditions, even if the client comes to us after the fact, I still send a 7-day rent withholding letter. Definitely can deal with things going forward. And there are some cases that say that it can even be sent after the 3-day notice is delivered to the tenant. Retaliation. So, we see oftentimes landlords who will bring eviction actions because the tenant complained to code enforcement or complained about, trying to get things fixed in the property. And if the landlord does that, then the tenant has another defense to an eviction. Where you see this a lot, and we'll talk about some of the COVID-related defenses, but maybe the landlord can't evict right now for non-payment, so they just terminate the month-to-month tenancy because the tenant is behind on the rent. Well, if the landlord's not allowed to evict right now, and they're trying to do an end run around other protections, that's really in retaliation. So that would be a defense that we're actually raising quite a bit right now. A few other defenses, just look at who the party is. You've got a lot of landlords who just are less sophisticated. Maybe they're trying to do it without a lawyer. Sometimes they file in the wrong name. Maybe it's corporately held, the property, and they file in their own name. One warning I would say is that property managers are authorized to file eviction complaints and actually move for default when the eviction is uncontested. So the moment you get involved, it becomes contested, and property managers aren't going to be able to represent the landlord. And then the last thing that's really important defense, if you have it, is payment. We see that sometimes where the tenant paid, but the landlord still filed the eviction. Discrimination, always be on the lookout for that. Tenants who are being treated differently because of their race, because of national origin. One issue though that I want, and those are protected, of course, under the Federal Fair Housing Act. But one thing I wanted to point out is that the Miami-Dade County Ordinance provides additional protections. It used to be important, at least before June, the Supreme Court's ruling on sex-based discrimination, which was extended to the LGBT community, used to have to rely on the Miami-Dade Ordinance in order to get protections. We don't have to do that now. I think that's based upon the Supreme Court, just be able to rely on the Federal Fair Housing Act. But the Miami-Dade Ordinance also provides protections for source of income discrimination. And that's really designed to protect people with Section 8 vouchers, which is a rental subsidy. But that's going to play an important role, I think, for tenants who have rental assistance. And there's a lot of rental assistance that are going out there. So that could be a defense to an eviction. And it also provides protection for victims of domestic violence as well. Equity and forfeiture is a defense that goes way back, actually goes to the Depression era cases that Florida courts disfavor forfeiture of leases, right? So in most of these situations, and especially when it would be unconscionable, inequitable, or unjust, and we may be seeing more of those circumstances, most of the time this is raised is in situations where the tenant then has the rent, right? So they can remedy the default in the lease. But we're going to have to do some sort of creative advocacy, I think, over the next few months. And this is one of those sort of long-standing principles that gives us some arguments we can make. And then every landlord-tenant rental agreement has an obligation of good faith, and that can be raised if the landlord is acting in bad faith. Can be raised as a defense. We've been able to successfully win evictions on the issue of good faith. So that's just a sort of like sampling of some of the defenses you'd want to look at when you're representing a tenant. But this is really what drives everything in evictions, is Florida Statute 8360. We always call it the rent deposit requirement, rent deposit statute. So a tenant, if they're defending an eviction, must do, so in addition to filing their answer, they have to do one of three things. They have to either deposit all past due rent, as the landlord alleges in its complaint, and they, along with the court registry fee, or they have to assert payment as a defense, or they have to file what we call a motion to determine rent, telling the court, I disagree with the amount of rent that the landlord is alleging, and I want the court to determine how much money I need to deposit to the court, how much money I owe. So you've got to do one of those three things. Now, many times our clients don't actually have the money, or don't have all of the money, so we really have to find a motion to determine rent if there is a good faith basis to bring one. Because if the tenant does not do one of those three things, the statute says that the tenant waives all defenses. So even if they have a defense to the eviction, it's waived. And the landlord's entitled to an immediate judgment for possession without a hearing and without scheduling mediation. So essentially, the tenant loses automatically. without ever seeing a judge, ever being able to tell their side of the story. So what we often see, and this is a real case here, this is a woman got served with an eviction. She responded to the papers the best way she knew how. She wrote a letter, and most pro se tenant answers look something like this. It's a letter to the judge telling them why they think they shouldn't be evicted. And in this, she mentions that there's some sewage coming down the wall and some problems in the place, and it was a really terrible slumlord condition. And she also says, and sort of better than most people, says that she would like to file a motion for a hearing on my rent determination, and also my rent was prorated. So there's some disputing over what the amount of rent was. Well, what happened to this tenant? She got defaulted, and judgment was entered against her, and actually this family got evicted. We were successful in appealing this case and getting the final judgment reversed, but it didn't stop the eviction itself. And the reason I bring this up is because our system really is designed to sort of rubber stamp and default. So few cases ever get to a hearing in evictions. And that's what your job as a lawyer will be, is to try to get that case to a hearing where, and once you can get there, the dynamics start to change a little bit. So if the tenant does have money or can deposit rent, they just go to the courthouse. The courthouses are closed, but they're open to deposit rent. So you can go down there and tenant can go in. There's a clerk's window for it. They have to pay a fee, 3% of the first 500 and then 1.5% for any amounts over that. But most of our clients are eligible to have that waived if they fill out the indigency affidavit, and any rent deposit amounts can be waived. So if you're representing one of our clients and they need to deposit rent, you can help them fill out the form, and they shouldn't have to do that. So when you file that motion to determine rent, what does it need to say? I mean, really, you're just disputing the rent for some reason. Best practices is to attach some sort of documentation. The statute doesn't say anything about attaching documentation to the motion. It says documentation must be provided. Our position is that's at the hearing. You need to have a hearing if there's a dispute, a factual dispute over the rent. So you're going to need some verification for it. But sometimes you have situations where maybe there is no documentation. So try to get the tenant to sign an affidavit. Come up with something that you can attach just to avoid that argument by a landlord. If there is a motion, there really should be a hearing. The case law here in the 11th Circuit is really, the appellate courts pretty much said you got to have a hearing on a motion to determine rent, assuming there's sort of a basis for it. The statute also says the tenant has to keep depositing rent as it comes due. So if another month comes due, hopefully that tenant will be able to deposit their rent. If there's a pending motion to determine rent, the tenant may not have to. If they have the money, it may be safer to have the tenant deposit, but if they don't, there's an argument that as long as that motion to determine rent is pending, then the tenant doesn't have to deposit anything yet. And there's a lot of terrible case law around discretion, mostly in the commercial context, saying that courts don't have any discretion, even if the rent is late, even if it's not the tenant's fault. But our view is that really that there's sort of constitutional concerns here, because somebody's being denied due process, not being able to present any defenses to an eviction. But unfortunately, we don't have a court that says that yet. But we've got a few cases that are percolating right now on that. But if you can overcome this, like I said, that's really the key. So you want help filing your answer, we're going to send you a master answer that has sort of like all the defenses that you can sort of delete out ones that aren't applicable. And then there's a really great online tool now at FloridaEvictionAnswerBuilder.org. Jacksonville Area Legal Aid created it. We helped out with giving input on what it needed to say. It's not, designed for Jacksonville area. It can be used anywhere in the state. And it'll create at the end of it, it sort of walks you through. It's designed for a pro se person, but I think, an attorney trying to do an answer, it will work really well for that as well. And it'll give you a Word document at the end that you can edit too. So it's a new tool. It's great. So after that, usually the court's first going to have a hearing on that motion to determine rent. They may tell your tenant they've got to deposit rent by a certain deadline, maybe a very short deadline. Usually that's resolved first, and if you can get past that, then evictions are sent to mediation. They're conducted by the court. It's free. Nobody has to pay for anything. In the world, pre-pandemic, sometimes you then went and saw the judge, and you might even have a final hearing right after the mediation if there was an impasse. I don't think that's really happening right now. And I would just say that if you are representing a tenant at mediation, you reach a settlement, review that form, because the standard form is actually pretty terrible. It has some sort of pro-landlord language in it about if there's a default in the settlement agreement, the landlord can file an affidavit with no notice to the tenant and get a judgment. So of course we always change that. We want a hearing if there's an alleged breach of the agreement, and don't be afraid to change that form. Beyond that, there is discovery allowed under summary procedure. Only depositions, though. You can get a court order to allow for other written discovery if you want to do that. Courts will usually hear the motion to dismiss first. I try to get, if there's a good motion to dismiss, you try to get that heard as early as possible. If you're trying to, if you're able to avoid the rent deposit requirement. And then ultimately you'll have a trial in the case. So hopefully you'll prevail, but I just think if the tenant doesn't, what happens next? A final judgment is entered by the court saying that the landlord's entitled to possession. The clerk will issue a writ of possession. It's a separate document which instructs the sheriff, but here it's Miami-Dade Police Department, to post the writ of possession on the door. It's a notice that says you have 24 hours to leave, and legally the police can come back 24 hours later and remove people's properties and possessions. In Miami, and these numbers here were pre-pandemic, usually it was at least 4 to 7 days before the writ was posted on the door, and then another 4 to 7 days before the sheriff came to remove people from the property. In a lot of the smaller jurisdictions, it's 24 hours is 24 hours. The police are there the day of the judgment, or the sheriff puts it on the door and then back the next day. There's no exceptions. Some tenants think that there's exceptions because of health, weather, children, disability. None of those exist. But as we'll talk about in a minute, right now the police department is not executing on writs of possession during the state of emergency. So cases can be appealed. Not a lot of pro bono lawyers have cases when they take a case that go up on appeal, but we had a few. Sometimes the attorney does everything right and the judge still defaults the tenant even though they shouldn't. And you have a right to appeal. You have to have that notice of appeal within 30 days. It's heard by the circuit court at least through December. After December, it's going to go to the District Court of Appeal. But that appeal doesn't stop the eviction. You're going to have to file a motion with that same trial court judge asking for a stay of the final judgment. Most of the judges will grant those if the tenant, especially if the tenant is able to deposit the rent going forward. But if the tenant moves out or is evicted, the appeal doesn't become moot because an eviction judgment can impact your ability to find future housing and eligibility for other housing programs. So because of those collateral legal consequences, an appeal is not moot, even if the tenant's no longer in possession. So that's the process. Now we're going to talk about the pandemic and what's going on. So everyone's talking about the eviction moratorium, and there's never really been one eviction moratorium. There's all these different things that are being sort of like layered on top of each other. As we go through them, you'll sort of see that it really depends on where the tenant lives, what's protecting them. So when most people are talking about the eviction moratorium, they're talking about the governor's moratorium. So he implemented one on April 2nd that first went out through the middle of May and just kept getting extended, and he kept extending it like a few hours before it was about to expire. And it was probably for non-payment cases, but I want to get you to the new one. So On the 29th of July, just last week, the governor issued a new executive order on the moratorium, and the press reported it as if like the moratorium was extended to September 1st. It was not, and I think you're starting to see some articles now in the last day or two recognizing that it really isn't much of a moratorium. I would say the moratorium has been lifted, but I will also say it's one of the worst written documents I've ever read, because it's not really clear what it means. So what it says now is that it's suspending a statute providing for final action at the conclusion of an eviction proceeding when it's for non-payment of rent for somebody adversely affected by the COVID-19 emergency. So the term final action doesn't really have a meaning in evictions. So the question is, and there's sort of a debate between the tenant advocates and the landlord advocates. The landlords think that means we can go up to executing on that writ of possession. We believe that means the court cannot enter a final judgment if the non-payment is because of non-payment due to COVID. And we don't have any guidance yet here. We don't have a court here that's decided. I know one circuit has basically said it's going to be up to each individual judge. So you can have, we may have different judges taking different approaches on this, which is not really what you want for housing policy. And then there's this third prong down here, the last thing at the bottom, which says that nothing is construed about relieving rent payments, and that was true in the first ones. But then all payments, including tolled payments, are due when an individual is no longer adversely affected by the COVID-19 emergency. I don't know what tolled payments are. Does that mean that rent payments for people who are impacted are now tolled? Not quite sure how that interacts with the section above. But our view is, if the person lost income because of COVID-19, they shouldn't have to put money into the court, and they shouldn't have a final judgment entered against them. Now, this is only good through September 1st. We'll see what happens at the end of the month as well. But evictions are going to start up. They're going to start quickly. I mean, it's very clear that they at least can probably send the notice. They can probably file the eviction and move forward. And that hadn't been happening. There were about 1,600 evictions that were filed in Miami-Dade County between March and third week in July that have just sort of been sitting there. So those are going to start moving probably too. So there was the Federal CARES Act. I'm sure you heard of that. The payroll protection was a big part of that. There was also an eviction moratorium in that. And that moratorium ended on July 25th, so it's not so important anymore. But what is important is that if the property is a covered property under the CARES Act, the landlord has to provide a 30-day notice to vacate. So all those notices we talked about under state law, if it's a CARES Act property, then they're going to need to be 30-day notices. So it can't be a 3-day notice to pay rent. Now it's going to have to be a 30-day notice to pay rent at any of these CARES Act properties. So what are these properties? Any of the subsidized housing. Our office is going to keep most of those cases in-house. We'll handle them because they're a little more complex. But one thing that's important about this is that it also includes some of the rental assistance programs or the Section 8 voucher program. So you could have a property that has maybe 200 units, but they have a tenant there with a Section 8 voucher. And if you read the text of the CARES Act, it's pretty clear that it applies to the property and not to the unit. So if that landlord has any rental subsidy, then they're probably going to be now a CARES Act property. So you have those federal programs, and then you also have the CARES Act properties are also any property that has a mortgage on it that is guaranteed or insured by the federal government. So that's talking about Fannie Mae, Freddie Mac, FHA, HUD, VA. So there are a lot of mortgages out there that were brought into the CARES Act as well. So you're talking about subsidized properties and then properties with federally backed mortgages. So there's some estimate that up to 30% of rental housing in the country falls under this additional protection. How do you figure out if it's a federally backed mortgage? It's a little tough, especially if you're representing the tenant. So there's a bunch of lookup tools. The National Low Income Housing Coalition has a really good one. But this is only for multifamily, so 5 units or more. It's a database, which I'll show you on the next page here, where you can put in, Miami, and it'll show you all the properties in Miami. You can put in zip codes and see if the property has a federally backed mortgage. It's a little harder to tell for your single-family home, so 4 units or less. Really, the landlord's in the best position to know that. So that's a situation that's tougher for a tenant to figure out. There's also a provision in CARES which says if the landlord has a forbearance, then the tenant gets all these protections through the length of that forbearance. Once again, that's one that's hard to figure out without sort of doing discovery, cross-examining the landlord to figure out if they have a forbearance. So, does the landlord need to tell the court or tell the defendant that they're covered under CARES? Not under the CARES Act itself, but we have an administrative order here that Judge Soto entered that requires any landlord, before they get a judgment of eviction, has to sign a declaration saying they are not covered under CARES. As of now, that executive order is in place through August 23rd. And if the landlord hasn't verified it, then they can't get the judgment. We'll skip this one. It's less important. This one I mentioned before, that if the property gets any sort of rental subsidy, then they're going to be covered under the CARES Act. So that could be a real defense here. You have a tenant with a 3-day notice. You can figure out they have a federally backed mortgage. Now that notice is defective because it's not 30 days. A big question is, how long do they have to send this 30-day notice? Well, the statute or the CARES Act actually doesn't have a deadline on this. And most advocates are thinking this is sort of a permanent change in the law, that if you're a CARES Act covered property, all notices now have to be 30 days. I've got 2 resources, and we'll send you this PowerPoint as well, 2 resources you can use for CARES Act information. Wanted to point out that some of the underwriters, FHA, Fannie Mae, Freddie Mac, VA, USDA, have issued these mortgagee letters that say that in these properties with mortgages that are backed by these entities, that evictions are suspended. It's written in a way that perhaps it only applies to properties where a lender has the property, but it really doesn't say that. And it's written in a way that can be argued that any landlord who has one of these mortgages is precluded from an action to evict. So something to look into if you have a property with a mortgage. So the Supreme Court had issued an order staying writs of possession, but that was lifted at the end of June. So clerks can issue writs of possession now. As I mentioned before, the courthouses are closed, except that we do allow access for people to deposit rent. And back in May, the chief judge instructed the clerk not to issue eviction summons in non-payment cases during the moratorium because of the governor's executive order. It's not an administrative order. It was through an email. I don't know if that's still in place. I'm guessing that it probably isn't, or it will be lifted soon, to sort of bring it in line with the governor's most recent executive order. Then the other layer of sort of protections we have out there is that in Miami-Dade County, the police department is not executing on writs of possession. And there's not a sort of formal order on this. It's done by a tweet. This is like the most authoritative thing we have. But it's been suspended because of the state of emergency. I think that woman that I showed you a picture of who was evicted during the last state of emergency, I think sort of played a part in this, at least back in March when it was implemented. The mayor didn't want people being evicted during a state of emergency. I don't know how long that will last, but it's still in place as of this week. But all of those things we just talked about, none of them impact the liability for the rent. The rent is still owed. There's a lot of movement from housing advocates around. Probably heard the phrase "cancel the rent." That doesn't exist. The rent, under all of these protections, the rent still is due. It's just providing protections from eviction. So putting this in sort of in context with the rent deposit, if you don't have the money, you lost your income to pay rent. How do you sort of reconcile that with the rent deposit statute? And that's going to be a real tough situation. Now, if the tenant lost rent because of COVID, I think under the executive order, the tenant has an absolute right to file a motion to determine rent and say, I don't owe rent. It's been suspended because it's due to the COVID emergency based upon the executive order. So, I think we, at least through the end of September, we've got that argument. Just other things, as I said, we're going to have to be creative. The statute's clear that tenants can raise legal and equitable defenses. Going back to that equity and forfeiture around unconscionable, unjust, and inequitable evictions, sort of thinking about what are the facts of my cases? Can I make a compelling argument for why the tenant shouldn't be evicted? And is the landlord acting in good faith? Counterclaims are going to be really important. So if you've got a counterclaim for the landlord failing to maintain the premises, even if the tenant didn't send the rent withholding letter, maybe it's not a defense to the eviction, but you might be able to bring that claim for, a counterclaim for the conditions, and then start setting off some of the amounts that are owed in rent. If the landlord's attempting to collect a debt they're not entitled to, you may have a Consumer Collection Practices Act. You got to be careful of litigation privilege there, and if there's a debt collector, you might have a federal Fair Debt Collection Practices Act as well. A lot of landlords, because they can't, couldn't file evictions, were sort of resorting to illegal evictions, what we call prohibited practices, where landlords were shutting off electricity, changing the locks. If a landlord does that, they owe the tenant at least 3 times the monthly rent, possibly more if there's actual and consequential damages. So that's another way where you can sort of find a counterclaim. And then look, if there's discrimination, a fair housing counterclaim. One thing I want to bring up is that source of income discrimination, we're seeing landlords who are refusing to take rental assistance. So there's rental assistance programs are popping up right and left from different the county, the city. United Way has one. If a landlord refuses to take it, I think that is a violation of the county ordinance against source of income discrimination. You might think, well, why would a landlord not want to take money from one of these rental assistance programs? There's a lot of small landlords in Miami. Sometimes they're taking the rent under the table, not reporting that income. Almost all of these rental assistance programs, the money goes directly to the landlord, and they're going to require W-9. So, but I'm not sure that would be a valid defense to, in court. Well, we want to hide our income, judge. So I think there's a potential there if you run into one of those situations. And then thinking about that motion to determine rent, which we've gone over most of these. You got to come up with a reason for the motion to determine rent, for either why the tenant should deposit less rent, or no rent, or delay putting the money in. So when you get a case, my first suggestion would be figure out the CARES Act applies using those websites, contact the client, figure out where they are in the process. Maybe they just got the notice. We're going to try to get you a case as early as possible, but it could be after the eviction's filed. Then figure out what the client's goals are, because some clients, maybe they are going to move out, right? Like maybe they don't have any income and they know they're not going to be able to afford the rent. But they just need time to relocate on their own terms so that they can get into wherever they're going. Maybe they have friends and family they can stay with. For other people, maybe they had a loss of income, but they're going back to work now, and perhaps they have some money. You might be able to negotiate with that landlord either a payment plan or reduction. So figure out what's important to the client. What do they really want? And for people who've never had an eviction filed against them, avoiding that eviction can be a real benefit. Next, figure out if the CARES Act applies from the client. You may have gone to those websites, but ask the client. Somebody getting rental assistance there, somebody have a Section 8 voucher, maybe you can find coverage some other way. So just to give you sort of two hypos of like how you figure out your legal strategy. Here's an example. Landlord got an eviction, filed an eviction on July 10th with a 3-day notice. The client's gone back to work and has half of the rent. And you think the CARES Act applies. So in this case, back in July 10th, that landlord couldn't have even filed the eviction. So you've got a defense. So here, you've got a basis, you file your answer, your motion to dismiss, your motion to determine rent, saying that they don't owe the rent because of the CARES Act. That's going to give you negotiation power to try to either do a rent reduction, to do that payment plan, because you can tell that landlord too, if they go forward with this and you're able to successfully defend it, then they may also owe attorney's fees and costs. And that gives you some leverage in trying to get a good example or a good resolution for your client. Second example, a client doesn't have any money, they've lost their job, but the landlord sent a bad 3-day notice, but they haven't filed the eviction yet. And the client's like, look, I've got family I can go live with. This is a perfect example where you might be able to step in, reach out to that landlord, negotiate a move-out date, and avoid an eviction. That's going to be a real benefit to that family. So just to wrap it up, things to think about. Having that tenant have an attorney makes a huge difference. Most tenants lose without an attorney, and you're just coming involved is going to be really helpful. I mean, so many of these tenants and families are really afraid about what's about to happen. They don't understand the process, and you being able to be there and help navigate it is really important. Sometimes we're just trying to get more time. We're not trying to delay for delays purposes. What we're trying to do is get more time so that the tenant can either get their life in order, get more income, get the money together. Maybe they're waiting for the unemployment assistance to come in. That's not working so great in Florida, or get back to work. Most of these cases, I mean, we're talking about litigation, but honestly, most eviction cases don't get litigated. They do sometimes, but you're probably going to just be negotiating and with the landlord. Be able to litigate if you have to, and that might get you where you need to get as far as settlement goes. Remember that moving is expensive, so moving out is going to cost that tenant a lot of money as well. We talked about why avoiding that final judgment is important. And then don't forget about the security deposit. The security deposit is money that belongs to the tenant that should be sitting in a separate account. And you can use that. We've been using that as like a source of funds to help negotiate payment plans. So that's sort of the end of my presentation. I'm going to have Jamie step in real quick to just talk a little bit about the pro bono referral process.
Thanks, Jeff. So as you can see, it's going to be very, very important for us to have you help us. And what we will do is when we get a case, if you're signed up, I'll email you. You will have all the resources that we can provide to you to successfully help the clients in these cases. The email will contain the client information, a copy of this webinar. Jeff has been doing this multiple times throughout the summer. Every time the law changes, hopefully this is the last one, but I for some reason I doubt it. The most recent webinar, the most recent PowerPoint, Jeff has put together various different documents that will help you in addition to that document builder that was contained in the PowerPoint. We will also offer mentorship and wraparound services. I have promised if someone gets to the trial phase that I will be there with you, or someone from the unit will be there with you. I have never seen a pro bono eviction case go to trial, but as soon as I say that, one will. But like Jeff said, probably the most important thing is to talk to the client, figure out what they want, Your assistance every step of the way is a win for our client, even if you help them negotiate more time to move out. Ultimately, we want to help our clients prevent the eviction on their record, because like Jeff said, it creates a bad cyclical course of action in their lives and in their families' lives.
And one thing I forgot to mention that Jamie's referencing is that, yeah, the law is going to change, right? Congress is, I mean, I don't know when Congress is going to act, but they probably will at some point in the next few weeks. Even the president this week said if they don't reach a deal on evictions, that he's going to do an executive order. So keep your eyes out for an update to this coming from the federal level. We've been doing this for several months, and it's changing every few weeks. I just want to end with this quote from Thurgood Marshall, because basically saying that evictions really aren't designed to be rubber stamps. That we're supposed to be trying to do justice in the case. And unfortunately, in Florida, if a tenant does not have a lawyer, the courts really are rubber stamps. So we're really counting on you to help us try to prevent as much homelessness as possible, and help our community as we sort of go through this pandemic. Last, and if you need help, Jamie will be available, and also the leaders from our tenants' rights unit, Chris and Sean, as well as myself. One of us will be able to help you, or one of our many attorneys who know this area. So we really look forward to working with you. And I'm happy to answer any questions if anyone has any.
Now, unmute yourself if you don't want to type out a question. No questions? Great. Well, we can't thank you enough. So thank you so much, everyone. And if you do have a question, feel free to contact me directly. Have a good evening. Thanks.